Morning again, ladies and gentlemen. At this point, I would like to introduce our second panel on congressional oversight and the judicial branch with our moderator, HEIDI KITROSSER of the University of Minnesota Law School. Ms. KITROSSER.
Thank you. All right. Well, thank you so much. I want to echo the thanks from this morning to the fantastic law review students. This is, as Bill said, this is an incredibly, impressively well-organized event. It's been wonderful so far. Thank you so much to Senator Levin, to Elise Bean, to Emily Barr, to everyone involved in making this possible. You know, I mentioned to a couple of people that what I've been really impressed by thus far, both last night's dinner event as well as what I've seen so far today, is how grounded the Levin Center seems, both in these crucially important national issues, but also in the community. I particularly got that sense last night at dinner about the deep ties to and love for Detroit and the state of Michigan, and an excitement that on the part of those involved in the Levin Center in being part of sort of an exciting new era for Detroit. So it's really, really wonderful to be a part of all of this. And I'm also very excited to get to introduce all of you to this second panel, which, as you just heard, involves congressional oversight and the judicial branch. Professor Marshall started the first panel by referring to McGrain v. Dougherty, which is, of course, the Supreme Court case in which the court recognized that Congress and committees of Congress have an inherent contempt power when individuals refuse to appear or to testify when subpoenaed before committees, but perhaps more importantly, or as importantly, in the course of rendering that holding, the court talked about the crucial nature of Congress's oversight function. And that opinion very much typifies, or I should say exemplifies and reflects the very important connection between congressional oversight and Congress's oversight role and the judicial branch, right? So in McGrain, the connection is particularly evident since you have the court essentially blessing and extolling Congress's oversight role. But there are so many other important interactions. So it was mentioned, for example, in the last panel, I think every speaker at one point or another talked about the importance of information gathering as part of Congress's oversight role, and the relevance of that to judicial doctrines and issues that arise in litigation, like executive privilege, for example. It was also mentioned that, you know, while few controversies necessarily make it up to the courts to be resolved in the realm of executive privilege, that nonetheless, in those informal communications that might, you know, not have anything directly to do with courts, sort of the shadow of judicial doctrine, the shadow of executive privilege looms large. Furthermore, you know, there are important political and other connections just between the bare fact of judicial or potential judicial inquiries and congressional inquiries, right? Right now, we're all well aware, as the senator talked about this morning, that we've had ongoing congressional inquiries regarding possible Russian involvement in the election. At the same time, we have a special counsel investigation, right? And so it's really important to consider the relationships, political, legal, otherwise, between these different types of investigations. And we have a panel, wonderful panel, well-equipped to help us grapple with these questions. So let me just briefly introduce each of the panelists. So Lauren C. Bell, who's directly to my right, is my right, your left, well, let's just say my right, is, rather than get too confused about stage directions, is a professor of political science and the dean of academic affairs at RANDOLPH-MACON College in Ashland, Virginia. And she's authored and co-authored numerous books touching on the U.S. Congress and the structure of different parts and the structure and functions of different facets of the U.S. Congress, including, among others, filibustering in the U.S. Senate from 2011, warring factions, interest groups, money, and the new politics of Senate confirmation, and many other publications. And then to my left, we have J. Richard Broughton, who's the Associate Dean for Academic Affairs and the Associate Professor of Law at the University of Detroit Mercy School of Law. He teaches in the areas of criminal law, federal crimes, constitutional law, constitutional criminal procedure, and his research ranges from federal criminal law and the intersection of law and American politics. Previously, he was a lawyer in the criminal division of the U.S. Department of Justice, Assistant Attorney General of Texas for capital litigation, and held many other positions quite relevant to our inquiry today. And then last, but most definitely not least, just beyond Lauren, also to my right, is Morgan FRANKEL, who comes to us very much from the trenches of everything that we're discussing here.
From the swamp.
Yeah, from the swamp, literally, right, from the swamp, which is apparently not been drained yet, right? So he's dredged himself over from the swamp, where he is the Deputy Senate Legal Counsel in the Office of Senate Legal Counsel. He's been with the Office of Senate Legal Counsel since 1981, so I think it's fair to say he's seen a lot, and we are very fortunate that he will be sharing his experiences and his expertise with us. So the way we're going to structure the panel is we're going to try to make it somewhat of a discussion. And so I'm going to start by posing a different question to each of our three panelists, that relates to their area of expertise. And then I'll follow up with some subsequent questions to all three. I'll encourage the three of them to have a discussion as well. And then given our lively and engaged audience, we'll try to leave at least 20 minutes or so, possibly a bit more, for questions before we break at 12:45. So let me start with you, Lauren. If you could talk a bit about what is meant by congressional oversight of the courts, why such oversight matters.
Sure, thanks, Heidi. I'll echo my thanks to the Levin Center, to Senator Levin, who's right here, to Elise Bean. And I especially want to thank the planners for today's symposium for including the judicial branch. I don't know whether anyone else noticed. I noticed that in the entire first panel, there was not a mention of the judicial branch in the discussion of what constitutes oversight. There are a variety of reasons we can get into why I think oversight gets neglected, or why the notion that oversight exists and is relevant to the executive branch sort of is ignored. But I'll just start by sort of maybe saying a little bit about what I think my role is here, and then talking about some examples. So within political science, and I should note that I'm the token non-lawyer, I'm a political scientist, and within political science, legislative studies and public law and judicial politics are separate subfields. So often, those folks who study Congress, those who study the courts, really kind of labor in wholly separate areas. The presidency is another subfield altogether. But I'm one of the relatively small number of political scientists that got interested in kind of the nexus between Congress and the courts, and so I started studying the judicial confirmation process. And what you realize as you start to study that process is that it's super messy. It's characterized by all of the same factors that affect the legislative process, interest groups and money and lobbying, but that it doesn't get studied, or at least at the time I started studying, it wasn't being studied very much. So from there, eventually I got tired of studying the confirmation process. I moved on. I started looking at filibusters. Then the Senate started filibustering judicial nominations, so I could never get away from those. But in general, based on my own experience, it's always been a little surprising to me that the courts are neglected as an area for the study of congressional oversight. In my experience, both in terms of my academic research, but I should mention I've also spent time as an American Political Science Association Congressional Fellow on the Senate Judiciary Committee and as a U.S. Supreme Court Fellow placed at the U.S. Sentencing Commission. So also in my practical engagement with these issues, it's clear that Congress is incredibly interested in the federal courts and what they're doing. It's also clear that many of the existing theories that political scientists and policy scholars have developed that help us to understand executive branch oversight can equally be applied to the judicial branch. And so Brian, for example, mentioned police patrol and fire alarm versions of oversight. You see tons of fire alarms in the judicial branch context, in particular with interest groups who are dissatisfied with something that the courts have decided, coming to Congress and seeking some sort of legislative remedy to the extent that they can. And we also know that courts can moderate themselves, their behavior. Judges and justices moderate their own speech in order to prevent a congressional response. So it's clear to me, sort of from an observational perspective, that the courts and Congress are engaged in this interplay that looks very much like what we see in terms of executive branch oversight. So to give a few examples, we can certainly talk about oversight of the courts in the context of appointments and thankfully more rarely, but also impeachment of judges. Budget control, right? Congress controls the budget for our courts. Issues of judicial pay have come up recently, and judicial pay as sort of a kind of a weapon to be offered in exchange or to be deployed in exchange, perhaps for concessions from the courts on issues that Congress cares about. We see Congress monitoring the courts and judicial decisions for policy congruence. Some of that is, of course, expected and benign. Recently, there's been a spate of congressional activity looking at judicial decisions in the area of patent law, and very much kind of a neutral look at, well, is the court interpreting what Congress was doing in ways that match what Congress intended? But we also see it in terms of more political issues and more highly politicized questions where Congress is saying, well, maybe courts shouldn't have jurisdiction over cases involving things like gay marriage or abortion. So we see efforts at stripping judicial jurisdictions. We see efforts to codify or overturn judicial decisions. I should mention, just in my recent look at this, there was about a 4-to-1 overturn to codify ratio in terms of the legislation that members were introducing in response to Supreme Court decisions. We even can look to things like the U.S. Sentencing Commission itself, which the Supreme Court in Mistretta, where it upheld the constitutionality of the Sentencing Commission, said, in effect, the Sentencing Commission is functionally equivalent to an executive branch agency and can be treated in that same way. So you see, in that context, a more rare but more direct example of Congress actually delegating its own authority to a judicial branch agency and then monitoring for compliance. And so really what I want to get at in this kind of quick summary is that if we start to kind of look at Congress's interactions with the courts, they don't look all that different really from the way Congress interacts with the executive branch. And in some ways, it's actually easier for Congress to oversee the judicial branch because so much of its work is centralized within the House and Senate Judiciary Committees. There was an allusion earlier in the previous panel to the decentralization of oversight and the competing and overlapping jurisdictions across so many committees and subcommittees on so many issues. But for the courts, so much of the work is centralized in the judiciary committees that it actually makes it easier for Congress to monitor what the courts are doing and to mount a response if it chooses. So I'll stop there, but I hope I've answered Heidi's question about kind of what is oversight in the context of the judicial branch.
Yeah. Thank you so much, Lauren, and there's lots that we'll follow up on there when we get into a discussion. But let me turn to Richard to ask him to at least kind of in an introductory manner start us thinking about how we might compare and contrast congressional investigations of the executive branch, like we heard about this morning, with criminal investigations.
Sure. So there are a number of ways in which congressional investigations can look a lot like criminal investigations, at least sort of superficially. Most obviously, we know that members of Congress call witnesses, gather evidence, question witnesses in ways that sort of look like cross-examination during hearings. They even use compulsory process to obtain information from witnesses. In fact, given its inherent contempt power, Congress actually has the power to incarcerate someone for refusing to provide information when compelled. So at least in these very superficial ways, there look to be a lot of sort of parallels between congressional investigations and criminal investigations. The major difference to keep in mind is that in a criminal investigation, the purpose, the underlying sort of constitutional rationale for what the executive branch or the prosecutor is doing is to enforce the criminal law, to seek criminal punishments. And this will necessarily involve the court system as well. As a constitutional matter, when prosecutors do that, they are assisting the president in fulfilling his constitutional obligation to take care that the laws are faithfully executed. Congressional investigations have a very different underlying purpose. It is not to enforce the criminal law. It is not to seek criminal punishments. Rather, the purpose of a congressional investigation is to aid the Congress in carrying out its legislative functions, right, to gather information so that Congress can carry out its Article I responsibilities. So if you think about the Russia investigation, for example, the special counsel, Bob Mueller, he has his obligation, which is to determine whether there is any criminality to uncover, and Congress's role is slightly different. While Congress may uncover criminality, that certainly is a part of any congressional investigation, that may happen. That is not Congress's underlying goal. It's to gather information to assist it in carrying out its Article I functions. So the Supreme Court has said, for example, in the Watkins case, which is one of these cases arising out of the sort of House Un-American Activities Committee era, that while Congress's investigative power is broad, Congress is not a law enforcement or a trial agency. That is certainly true as far as it goes. Congress has no power to prosecute and punish anyone under the ordinary criminal law. But I would still say that Congress does engage in a kind of law enforcement. That is, it engages in actions to enforce Congress's own privileges and prerogatives, as opposed to the criminal law. By the same token, and this I think is an aspect of the relationship between Congress and the executive branch that is perhaps underappreciated, the executive branch not only enforces the ordinary criminal law, it also has an obligation to enforce those criminal laws that are specifically designed to protect Congress as an institution. So think about things like the obstruction of Congress statute, or the contempt statute, or the statutes that criminalize violence committed against members of Congress. So there are times when congressional investigations and criminal investigations will overlap to protect Congress as a body, Congress as an institution. Now, harder questions do arise when we start talking about the executive branch's role and its refusal to do what I just said, when the executive branch refuses to defend congressional prerogatives. Oftentimes we see this when it is the executive branch itself that is under investigation by the Congress. That, I think, is when Congress's backbone, Congress's willingness to assert its own institutional prerogatives becomes the most important, when Congress cannot count on the executive branch to protect its prerogatives. So just in terms of recent examples, think about something like the IRS targeting investigation, right? So Lois Lerner, who was head of the tax-exempt office for the IRS, had been held in contempt of Congress. She claimed that she had, she was asserting her Fifth Amendment privilege before the House Oversight Committee. The Oversight Committee took a vote, said, we think that you have waived your privilege by essentially making an opening statement in which you claimed your innocence, right? The House eventually held her in contempt. This went to the United States Attorney for the District of Columbia, and the United States Attorney determined on his own that she had not waived her privilege and therefore refused to prosecute. So that leaves Congress in a situation where it either has to simply abide by the decision of the United States Attorney not to prosecute the case in criminal court, or to use its own institutional prerogatives to try to gather the information. So there is interbranch enforcement, which is where Congress and the executive branch sort of work together to assist Congress in carrying out its functions. And then there is kind of intra-branch enforcement, which is when Congress cannot rely on the executive branch and has to enforce its prerogatives itself.
Great, thank you. And also a lot to follow up on there as well. But let me turn first to Morgan. So Morgan, Lauren talked about some of the ways in which Congress oversees the courts, right? But you and some of the preliminary discussions we had mentioned that Congress also often finds itself as I think you had put it, a supplicant to the courts, right? That it may find itself, through its lawyers, defending a lawsuit, representing senators themselves subpoenaed to testify, filing amicus briefs. Could you talk a little bit about that?
Sure. Let me say by way of introduction, and I'll try not to repeat the first panel, but I'm here for two reasons. First reason is because my mother went to Wayne. The second reason is because I've been in my office in the Senate for 36 years, which not coincidentally is the period of time the first panel identified as beginning the precipitous decline of congressional oversight. So I'm a witness to that. Broadening from oversight to interactions between the branches. The interactions are quite complex. Congress oversees the budget, salaries, rules, cameras in the courtroom. There are judicial issues of interest to Congress, just like there are many issues of other entities of interest to Congress. But Congress also has interactions as a participant in judicial proceedings. Everyone thinks of the executive branch as interacting with the judiciary, and of course it does many, many times more than Congress does. But in a number of areas, Congress appears in the courts as well, which makes quite complex the interaction sometimes between the branches. And let me just tick off some of the common ways in which we end up in the courts. First, people sue congressional parties, senators and staff and committees. They shouldn't do that. I don't want to encourage anyone here to think they should do that. And there are privileges, but those privileges have to be asserted. So we appear in courts telling the court to dismiss a lawsuit against Congress to protect Congress's, well, we've litigated the constitutionality of the filibuster. Is the filibuster unconstitutional? And people have sued the Senate over that. We also defend the constitutionality of laws when challenged, especially when not supported by the executive branch. The Department of Justice normally defends the constitutionality of statutes, but in various cases where the Department of Justice or the President find that a statute is unconstitutional or intrudes on executive privilege, on executive prerogatives, Congress will intervene or more common appear as an amicus in support of constitutionality statutes. I started working my job the day the Supreme Court granted certiorari in the case called INS v. Chadha, legislative veto, and we defended the legislative veto in that case unsuccessfully. And in fact, you can also trace about 36 years to the number of cases, separation of powers cases that Congress has lost while I've been in that office. We've won some as well. More frequently, congressional parties appear as witnesses in court proceedings, in grand jury and in court proceedings, in a variety of of kinds of cases. There can be a civil case arising out of a constituent matter in which a caseworker has relevant testimony. It can be a criminal prosecution for obstruction of Congress, or perjury, where materiality is one of the elements the government must establish, and therefore the Congress must supply a witness to describe what it is that the committee was doing and why it mattered. Members also participate on their own, either as amicus, groups of members who file amicus briefs on all kinds of issues, and sometimes members bring lawsuits themselves in their official capacity. There are a number of lawsuits now pending over the emoluments clause, whether the president is violating the foreign or the domestic emoluments clause. There are several lawsuits, one of which was initiated by a group of members, which raises issues of congressional standing. But is another example of Congress appearing and interacting in the courts. There are issues over how laws affect Congress. There's a plus and a minus to representing the Senate or the Congress in judicial actions involving laws. The plus is we write the laws, and so if we don't like this, we can change the law, in theory. The minus is courts can say, you wrote that law, and you don't like what it says. For example, Freedom of Information Act does not cover Congress. Congress is exempt, but it covers executive agencies, and as was alluded to this morning, issues arise over congressional documents in the hands of executive agencies, and there's been quite active litigation in that area. Very easy for the courts to say, you didn't draft this with yourself in mind, redraft it. Don't ask us to do it for you. Redraft it and make it the way you want. Congress also appears in courts to actively support congressional investigations, and I'll name two situations. One, to get use immunity orders. There's a statute that permits Congress, a committee, or a House to go to court, get an order from a court providing that a witness must testify, notwithstanding a Fifth Amendment objection. But the price of that requirement is that the witness nothing the witness testifies can be used against the witness in a criminal proceeding. It's called use immunity. The court's role is ministerial, except when the courts interpret the meaning and the effect of that statute in the Fifth Amendment, as they did after the Iran-Contra proceedings, when Oliver North and John Poindexter gave testimony under use immunity, and the D.C. Circuit turned it in essentially to transactional immunity. And if people are interested, we can get into that later. But the important point here is that the effect of those decisions is if one looks at the number of use immunity orders Congress has obtained since then, it has plummeted because the consequences are draconian. Finally, subpoena enforcement. Our office specifically can be directed by the Senate to go to court to enforce subpoenas to non-federal officials or officials not raising federal executive objections, but raising personal privileges. The most recent, we've done that 6 or 7 times in 40 years. It's not common. The most recent example was a lawsuit brought by PSI against the principal of an organization called Backpage.com that is a online website service for what I'll call adult services. And the PSI was doing an investigation into the use of the internet for sex trafficking, and there was a First Amendment objection raised over production of documents, and the Senate unanimously authorized PSI to go to court, and we prevailed, and the company was ordered to turn over 1 million documents. So another example of us as supplicant to the court, in addition to the other methods of punishing or enforcing subpoenas, there is a method where we go to the courts and ask for their help and for a court order. So that's a variety of ways in which we interact with the courts other than the traditional forms of oversight.
Wonderful, thank you. So I have just a couple of follow-up questions for each panelist, and then I'll invite the panelists to raise questions or perhaps comment on each other's comments before turning to audience Q&A. But in terms of my follow-up questions, I'll go in reverse order from the earlier order. So Morgan, let me turn back to you. Among the many, many really interesting examples that you gave, one that I thought I'd follow up on is FOIA. As you mentioned, FOIA, Congress wrote FOIA so as to not apply to Congress. But as you mentioned, and as was mentioned in the previous panel, sometimes it's not so clear, right, when congressional communications may or may not properly be subject to FOIA requests. Could you talk a little more about that, maybe explain to the audience how it is that despite it not applying to Congress, Congress can get caught up in FOIA requests and
Sure.
the wrinkles there?
The Freedom of Information Act incorporates the Administrative Procedure Act's definition of agency. It is agency records that may be obtained under the law. An agency is defined specifically to exclude the Congress. So if you send a FOIA letter, a request to a member of Congress or to a committee, you may get a response that says, we're not covered by FOIA. It cites a statute, cites some cases. But because Congress is not an agency, Congress is also not an agency for purposes of the part of the law that exempts from mandatory disclosure records in the hands of an executive agency that are interagency, that are communications between agencies. So if they're deliberative documents between the Agriculture Department and the Energy Department, those may be exempt. If there are documents as interagency, deliberative memoranda, if there are documents that go between an executive branch agency and a congressional committee, the same document in Congress's hands is exempt, but in the agency's hands may not be exempt. And there's a quite long and tortured history, especially in the DC circuit, in the area of intelligence oversight and income tax administration and oversight between the committees of Congress that do that work and the intelligence community and the IRS. And there are cases in which it is clear, I'll say, that an agency in the hands of an executive document in the hands of an executive agency is really a congressional document. And the case law derives from the days before Congress had secure methods of keeping intelligence documents, national security classified documents, and would give to the CIA a copy of a transcript of a congressional hearing because the CIA had more secure facilities. But it was just for safekeeping for the Congress. It was a congressional transcript. And the courts said that's a congressional document, even though the CIA has it. The CIA doesn't have it in the practical sense. Going to the other extreme, based on a bunch of intervening cases, there are committees now, more in the House than in the Senate, but there are committees that have written to the agencies they oversee, saying all documents that we ever exchange with you are congressional records. And the documents that you write in response to us are congressional documents not covered by FOIA. And so an emerging issue will be the scope by which Congress can retain control, what it has to do to retain control of documents that are in the hands of the executive branch for a variety of reasons.
Thank you. And Richard, to follow up with you, you talked a little bit in your initial comments about the interactions between congressional and criminal investigations, and Morgan touched on that also when he talked about immunity. But if you could elaborate on that a bit, I mean, some examples that come to mind, obviously immunity, as Morgan talked about, the impact perhaps of congressional testimony on criminal proceedings, vice versa. So just some of those, interplays that can arise.
Sure. Yeah. I mean, immunity is a great example of how there is this sort of relationship or interplay between what Congress is doing and what criminal prosecutors are doing. Under the statute, so it's governed by these two provisions, 18 U.S.C. 6002 and 6005. Under the statute, the court, as Morgan said, does have a ministerial role. It pretty much has to grant the immunity application. But there's another provision of the statute that requires Congress to give notice to the Attorney General 10 days in advance. And then there's also another provision that allows for the Attorney General to, for a very short time, delay the granting of the immunity order. But that's important because that is designed in part to give the Attorney General time, first of all, to give the Attorney General notice, right, because it may affect a criminal investigation, but it also allows for the Justice Department and Congress to sort of talk more thoroughly about whether this is a good idea. Because as Morgan mentioned, the Oliver North prosecution, the D.C. Circuit's decision in the North prosecution, effectively transforms use immunity into transactional immunity in a situation like that, right? So you have to remember, North doesn't just get immunity and give information to Congress. He testifies on national television over the course of multiple days. Virtually anyone in the country would have had access to the information that he was giving to Congress, and that's what created the problem for prosecutors in the North prosecution. Because if you read Judge Wald's dissent in the North case, one of the arguments that is made there is that there were witnesses in the North prosecution who testified before the grand jury even before North had given his testimony before Congress. But nevertheless, you wouldn't know whether the fact finder was relying on the immunized testimony or the non-immunized portions of the testimony. So that's why if you have a nationally televised, witness testimony, it's going to create very serious obstacles for prosecutors moving forward. So there's those kinds of relationships that I think are important. Another question is, how much do congressional investigations help prosecutors? They certainly can. I mean, there's certainly information that congressional investigators can obtain that will then be turned over to prosecutors and assist them in a prosecution. And then the other question, the related question, is when do prosecutors essentially gather information that could end up helping Congress? And in particular here, I have in mind the example of impeachment. So we may be seeing an example of that happening right now in the Russia investigation. We don't yet know, but compare and contrast, for example, the Jaworski report in the Watergate investigation, which really doesn't allude specifically to impeachable offenses, but kind of lays out the roadmap for impeachment. With the Starr report, involving President Clinton, where the Starr report more specifically identifies potential impeachable offenses that Congress may want to consider. Starr doesn't say, you must impeach the president on these particular grounds, but says instead, here's the evidence that may constitute evidence of impeachable offenses. So there are very interesting relationships and dynamics between prosecutors and Congress.
Yeah, terrific. And Lauren, let me turn back to something that I think was implicit throughout your talk, but you particularly highlighted at the end when you said, look, some of congressional oversight of the judiciary, a lot of it is routine or at least benign, but you suggested some of it is less so, right? And so I guess what I'm wondering is if you have in mind criteria by which we might distinguish benign from what I guess we can call malignant congressional oversight, of the judiciary, and relatedly, how, if at all, you see something that was talked about a lot earlier in the day, political partisanship, playing into that calculus.
Yeah, so great question, especially because I'm not sure I do have a clear definition. I'm kind of taking the Kevin Kosar approach to, I know it when I see it, right? I thought it might be interesting, though, in answer to that question. So in the piece that I wrote for the Law Review Symposium, I include a table of congressional efforts to strip judicial jurisdictions for the last 3.5 Congresses. And I'll just read you an example of some of these. They're all similar. The Defense of Marriage Act, the Americans with Disabilities Act. There was a comprehensive effort on religious freedom, privacy, and marriage equality, immigration, whistleblower hearing deadlines, defense of marriage again, defense of marriage, abortion, assaults on state and local law enforcement officers, voting rights, visa refusals, immigration. And so at some level, what you're not seeing are sort of the kind of generic and uninteresting kinds of legal questions that might come up. What you're seeing are these sort of hot-button political issues where members of Congress are saying, we don't like what the courts are doing. Elsewhere in here, I've got some fairly fantastic quotes. I won't be able to find them quickly, but things that members have gone to the floor to say about the destructive nature of the federal judiciary, or the absolute ways in which the courts are out of step with American values. And so to me, there is sort of that's where that line maybe blurs between sort of kind of Congress doing its due diligence and members of Congress seeing what happens in the courts, or seeing the courts as extensions of their own political will. And I think that, to me, is where I would start to draw the line. It's not an easy one, because, of course, members can certainly say, well, I believe that this is a important issue, but we see it in other ways, right? Of course, the ability to consent to presidential nominations to the courts is absolutely essential, and in many instances works in a pro forma way. And then you see something like what happened to Merrick Garland, and you say, well, is that Congress simply exercising its kind of institutional prerogative, or was there something more happening there? And I think what we can say, and I think what is good, is that to a large extent, members of Congress recognize, perhaps with the exception of efforts to strip jurisdiction, that once judges are on the courts, they're at an arm's length. They are. We don't look at them as individuals and try to address individual failings for the most part, but our time to kind of influence the courts as an extension of our own, if we're Congress, as an extension of our own policy goals, is during the confirmation process. And so increasingly we're seeing this sort of no holds barred, anything goes approach to questioning potential nominees, to the point where you have references in the Chief Justice's year-end report on the federal judiciary saying, like, we've got to treat people better in this process. We're not getting people who are willing to put themselves through this. And so I think it's hard to draw a clear line, but I do think there is some indication, or there are things that we sort of look at and say, this really does go far beyond kind of Congress exercising its normal perhaps oversight abilities, and really tread into Congress trying to use the courts as an extension of their own institutional will. And an example of this even goes back, this is not new, right? In 2007, there's a hearing on the Commerce, Justice, State Appropriations Bill. Justice Kennedy goes to Congress. He's sort of the designated representative that year to go and pitch the court's case for its own budget. And the late Senator Arlen Specter literally spends the entire time sparring with him over cameras in the courtroom, right? So it really wasn't about, let's make sure we fund the courts. This is something that's important. It was, well, we'll think about this, but here's this other thing we really want from you. And that tension is still certainly there. That tension is there on the judicial salary issue, right? It's fascinating to see that interplay. The Chief Justice in his year-end reports, again, for like 5 straight years, talks about how Congress is failing to provide for the judges, and then in 2014, they get their pay increase. Basically, they have to give it to themselves. They get their pay increase, and suddenly the subsequent year-end reports are all things like, it's an honor to work with such distinguished district court judges. And this year, I'd like to focus on the appellate courts, and the appellate court judges are so fantastic. And so the tone totally shifts, and again, there's this interesting interplay where the courts also recognize that, okay, now we like don't make any waves for a while, and then maybe we can come back when things have settled down a little. And I would see that as more normal, not so much the holding the pay hostage, but the sort of ebbing and flowing of relationships. But I do think we've seen a shift.
Really interesting. I think there's often a lot to the I know it when I see it is at least part of the answer. And it reminds me of, I always joke with my students that the favorite answer of a constitutional law professor to almost every question is, it depends. Which actually reminds me of a great Onion headline, which was Supreme Court issues landmark, it depends ruling. There's a lot to that. So what I'd like to do now is invite any of the panelists, or all, if you'd like to do so, to, if you want to jump in and follow up on someone else's point, ask a question, make a comment. Anyone want to jump in? Or I can go in order if you think each of you would like to say something. Morgan, did you want?
No, I listen to the audience.
Oh, okay.
I'm fine.
Okay, what about you? Did you want to, Richard, or would you like to turn to the audience? Okay, well, we're eager to hear what you guys have to say. So let's turn to questions from the audience. Yes, starting way up there.
So Professor Bell talked about a number of instances in which Congress over the last several years in which Congress has tried to limit the jurisdiction of the federal courts, typically regarding some what we might call hot button issues. Could you talk about the extent to which Congress was successful in doing so, and to the extent that it was successful or unsuccessful, what factors contributed to those outcomes?
So in general, Congress is not typically successful at these sorts of efforts, right? These kind of standalone, we're going to introduce a piece of legislation to strip jurisdiction. It's very rare, and you can go back historically and find examples of that, certainly during the civil rights movement and things, but in recent years, Congress has not been particularly successful. You'll see a bill maybe get out of the House, but then it'll die in the Senate. Among the reasons that I think these standalone pieces are not particularly successful is that if you look at who is proposing them, they're not your members who are considered the most stable or bright.
House members, you mean, I'm sure.
I'm talking about House members. Well, and I would say also that these rarely originate in the Senate, very rarely. I mean, these are all coming from members of the House. You all probably wouldn't have to think very hard to come up with names, given the qualifiers I've just given you. And so I think that's a big part of it, and that gets to Heidi's question, that often these are political efforts, they're point-scoring efforts, or, again, to Brian's earlier point, they're offered in response to some kind of interest group fire alarm, right? That a group says, a group or set of groups says, we're really upset about this decision that the courts have made. Someone needs to do something about it, and so this is sort of a quick way to do something about it. There are more sophisticated efforts at this, often involving Congress actually changing the law when it recognizes that there's a problem. But yeah, these are more political, and that's why I raised them.
Just to chime in on that, there are cases, not often, but a couple have gone to the Supreme Court recently, in which Congress has changed the law applicable to pending cases.
Right.
The doctrine, whether that infringes on court's powers under Article 3, Congress can't tell the court the plaintiff wins in this case, but it can change the law, even if that dictates result that plaintiff wins. and can do so subject to ex post facto and bill of attainder and some other constitutional provisions to affect a particular case. And that has risen a few times recently, and then the courts have looked into whether, Supreme Court twice has looked into whether, in fact, Congress is intruding into its prerogatives.
Yes, up front.
Thanks. Hi, Jonathan Llewellyn, University of Tampa. Question again for Dr. Bell, related to, as a follow-up to Heidi's question earlier about the character of oversight. So one of the things that and nominations hearings as oversight, it's one of the things that I think is interesting about the distinction between oversight of the judicial branch and the executive branch is that the committees holding these nominations hearings, they kind of know what the agencies are going to do because they do a set amount of things. And they know, okay, Department of Energy, you're going to be regulating the same stuff that you regulated last year. Whereas with the judicial branch and judges, they don't necessarily know what cases are going to come up and what issues judges are going to be deciding on. And so how do you think that, well, let me back up. So then what would effective oversight through those nominations hearings look like given that uncertainty? And then will that oversight only be but so effective because they just can't predict what these judges might even be addressing in the future, let alone how they're going to address it?
Yeah, so I mean, I think in some ways you kind of in the last comment answered the question the way I would, is that oversight through the confirmation process for judges is of questionable effectiveness. And in sort of the same way I'd say that oversight through trying to strip jurisdiction is of questionable effectiveness. In terms of kind of the impact, right, the nominee to head the Department of Energy, you know kind of what they do or what they're supposed to do. I think it would depend to some extent on the level of court you were looking at, right? I mean, with district court judges, you would ask certain specific questions, and the understanding, of course, is that district court judges are incredibly constrained in what they're going to be able to do anyway. But you're absolutely right. They don't really know necessarily what cases are going to get there. I mean, we could push that a little further. Certainly the court's caseloads are functions of what Congress has done in terms of determining what counts as a federal crime or creating a giant new piece of domestic legislation. And so I'd say that there is some, if you look at the types of questions that get asked, I think you could, I haven't done this, but I think you could kind of look to see, I think you would see that there are some similar types of questions being asked of nominees to the executive branch as to the courts, particularly in the context of domestic policy. So right, we know what the nominees for HHS are supposed to do, but frankly, the same members of Congress want to know whether the judges who are going to be presiding over the cases brought under the Affordable Care Act are going to decide them in the way that Congress intended as well. So I think you would see some similarities. I think you're absolutely right, though, that there'd be limits to effectiveness given the uncertainty of what happens in terms of judicial business.
Yes, question over there. Yes.
Hey, Kevin Kosar of R Street. When our program this morning opened, reference was made to McGrain versus Dougherty. And for those who don't know the case, it featured McGrain, a deputy of the Sergeant at Arms of the Senate, traveling to Cincinnati to nab Dougherty and physically detain and bring back, and Dougherty was briefly imprisoned because he refused to appear before the Senate. As I understand it, nothing like that has happened since the 1930s. Congress just doesn't detain folks. And my question is, why? Has the legal landscape changed in some way? Has its powers been reduced? Is there just more effective ways of getting what you want?
A couple of reasons. You're right. I think 1935 maybe was the last time, something around then. A couple of reasons, I think. One is there are alternatives. The criminal contempt statute was passed in 1857 to provide an alternative. The civil enforcement statute was passed in 1978 to provide another alternative. But more importantly, I think two reasons. One, time. It takes a lot of time on the floor to hold a trial. And the same reason that in judicial impeachment proceedings, the Senate has used in the past in the modern era has used a committee to receive evidence and certify a report to the Senate, not for presidential, but for judges, rather than having 100 senators sit and listen for days to testimony. In the case of inherent contempt, it just is not appealing to use valuable floor time to sit there and listen. The other reason is it's not what people came to Washington and were elected to do. You have sitting in judgment on one person. All you do is make enemies of that person and their family. You don't get any credit. It's one thing if it's a judge who is in prison for taking bribes and the House impeaches him. Well, there's going to be a proceeding and it's going to happen right away. But if there's a witness, have a trial as whether the witness had a First Amendment objection and rule on it and put him in jail, it just isn't an attractive thing that members want to do. Those are my surmises as to why.
I follow up on that a little bit. I think the time-consuming aspect of it is certainly one. There's a kind of argument about the seemliness of doing so as well. But I think another argument is how effective is it, depending upon the punishment, right, or what ends up being the consequence of finding of guilt for inherent contempt. The amount of time that the person is incarcerated is only supposed to last until the end of that Congress. So that's going to be a relatively short amount of time anyway, particularly if the inherent contempt proceeding occurs later in that Congress. Now, it's a slightly more complicated question with regard to the Senate because of the argument that the Senate is a continuing body. But nevertheless, I think that's one of the other arguments is whether inherent contempt provides for a really effective remedy anyway. But with regard to the alternatives, it is true that there are the civil enforcement alternatives as well as the criminal contempt alternative. But this gets back to something that I was saying earlier, which is, well, at least with regard to criminal contempt, what if you can't count on the Department of Justice to prosecute the contempt case? We know that we have seen that numerous times over the last few decades with regard to executive branch officials. So that leaves Congress in a position of having to sort of realize that the ball is back in its court, and what do we do? Inherent contempt might be kind of a last resort remedy.
I also think it's sort of a fascinating exercise to think about how the media environment has changed. Could you just imagine media coverage today of an inherent contempt imprisonment? So that's, that might color things as well. Other audience questions for any or all of the panelists? Yes, in the middle over there.
Hi, my name's Adomis Raucus. I'm an editor of the Law Review here at Wayne State. And kind of in the context of media coverage, and we've seen this recently, how has being legal counsel to the Senate, how has that job changed as technology and social media has given people more access to their representatives and at the same time also made them more vulnerable, as we've seen recently with Senator FRANKEL, Representative Conyers. So how has the introduction of this technology changed kind of the legal context that you face as counsel?
Well, it's created a lot of issues that didn't exist when I started my job. For example, copyright issues for websites for members. There's a provision, a committee report provision in the Copyright Act of 1976 that says that use of copyrighted material in floor proceedings and in hearings is an example of fair use. It is not an infringement. So senators can blow up a poster of a headline of newspaper, or put an article in the Congressional Record, or make other legislative use. But the question arises, what if the committee is not going to publish its report as a formal Senate report by GPO, and instead is going to put it on its website, which happens now universally. They get published often, but is there copyright protection for that? Speech and debate clause, what is the speech and debate clause immunity, which immunizes members for their speech in committee reports and on the floor, but what about staff reports that are distributed through the web? There are other issues that arise. There's litigation that thankfully has not infected Congress, but in public officials out there who have blocked access to social media sites. They're sometimes personal social media sites used for official business as well as personal business. And there are officials, some are state and local and others, who have turned off somebody's access because they're off topic or they're profane or they're sick of hearing from that person. And now there's litigation brewing as to whether that's a First Amendment problem. So I would say our office, I think, is not affected directly by social media. Nobody cares in comments and blogs and tweets about the Senate Legal Counsel's office. But there are a lot of issues that arise that didn't used to arise.
And actually, if I could just extend that really excellent question to the other panelists as well. Lauren and Richard, if you want to jump in, ways in which you see changing technology, the changing media environment of the last few decades impacting the areas that you've talked about. Let me turn to you first, Lauren.
Well, I think we can go back to the 1960s and just widespread television coverage of Congress, and then the 80s and the advent of C-SPAN. I mean, that's when we started to see members behaving in ways that, well, frankly explain why the courts don't want to put cameras in the courtroom. But that's absolutely the reason. So to me, the social media piece or the changing media environment hasn't changed things dramatically in terms of the substance. It's changed the scope and the amount. You just see more of it in different venues. But senators were using television. They were using the congressional record. They were using their websites to complain about nominees or to tout their efforts to strip jurisdiction, 20 years ago. Now you're just seeing them tweet that or post it on Facebook. I'm not sure that it's substantively different. It's just quantitatively different, and the venues seem different to me.
Yeah. Richard, what would you like to
So Arthur Lyman, who was counsel on the Iran-Contra hearings, tells this great story about a conversation with Steven Spielberg, who was talking about the way that the camera angles were used with regard to Oliver North's testimony, and that North was shot from the floor up, which Spielberg described as the hero's angle, whereas the committee was shown from what was described as the villain's angle, right? Sort of depicting an inquisition. And so there was always sort of this argument that the way that North was depicted, in addition to the content of his testimony, had a lot to do with North sort of being depicted as an American hero during the Iran-Contra hearings. But more recently, the other thing that I would say with regard to media coverage is it seems like we know a lot more about Mueller's investigation now than maybe we have ever known about other independent counsel or special prosecutor investigations. There's a tremendous amount of investigative journalism going on and a real resurgence of investigative journalism in this country. And I think we're seeing now a lot more information coming to us about things that I think in years past would have been well-kept secrets.
Yeah.
The other thing that happened during the Oliver North presentation that would not happen today is in the corner of the witness table, there was a stack of telegrams, yellow, some people remember telegrams, supposedly and probably supportive of North. And as he testified, his lawyer arranged for them to be put up with the stack. So members of Congress looking down at the witness, but looking up at a stack, thought twice. Nowadays, I guess you'd count tweets or something.
I was going to say, now they'd probably have a screen up now with like a string of tweets going by. Elise, yes.
I was wondering if you've done any looking at or can give us your impressions about how courts feel about congressional subpoenas. Do they tend to want to enforce them, not want to enforce them? Is there a difference between the executive branch and whether a subpoena is directed to a private individual?
There really haven't been enough. The statute's been used, civil enforcement. Criminal is up to the Department of Justice and judges and juries. The civil enforcement statute has been used half a dozen times, mainly for PSI. 3 of the 6 times have been, in fact, PSI. 2 organized crime hearings in the late 70s, early 80s, and the back page example that I gave. And then in ethics proceeding, the court, and the Senate won those 3 cases, though in 2 of the cases, the mafia witnesses asserting the Fifth Amendment went to jail for the duration of the proceedings. So the subpoena was enforced, but they chose not to testify. So we won the court case, but didn't get their testimony. The other uses, there was one in Iran-Contra that failed, I think on the merits. It was an unsettled case coming out of Iran-Contra. Then there were 2 that succeeded. One was Senator Packwood, former Senator Packwood, and his diaries. Some may remember it was a sexual harassment investigation by the Ethics Committee before sexual harassment was everywhere. And Ethics Committee had access to his diaries voluntarily, and then he revoked the access. We ended up going to court against Fifth and Fourth Amendment assertions and prevailed. The other was in a judicial impeachment trial of Judge Hastings, who's now a congressman on the House Judiciary Committee, but at the time was a federal judge who had been acquitted of bribery, but was impeached by the House. And he had a co-defendant who he had been tried separately from, who was convicted. And so at the impeachment trial, the Senate Impeachment Committee subpoenaed the only person other than the judge who knew what had happened that day and who faced no liability because he'd already gone to prison. He chose not to testify. He was immunized. He still chose not to testify. And he ended up going to jail for 44 days, but a short period, because of the duration of the proceedings until the Senate voted and removed Judge Hastings from office and he got elected to Congress.
Did you want to add anything? You're good. Okay, I think we have time for one more question. Oh, yes, right there. Andy.
Yeah.
Yes.
Andy Wright again. I was curious about 2 Watergate examples about the symbiosis between the courts and congressional investigations. One was just to note, it's my understanding from the Slow Burn podcast that the tapes came from an interview, a Senate interview. Fred Thompson asked a question of Butterfield, and that's how they found out about the tapes, which obviously became the center of the litigation. But on the flip side, the trial judge in the Watergate trials at sentencing withheld sentence subject to their participation in the Watergate hearings in Congress. And I'm wondering if that's still a viable strategy for a trial court judge in the modern era now that we have sentencing guidelines, et cetera.
Any of you want to?
I don't know the answer to that. Plea agreements certainly usually have cooperation with the government, and that can be interpreted by the government, by a court, to include with the congressional committee. But when the witnesses were executive branch witnesses, one has the same issue as whether the Department of Justice, unless there's a special counsel, would seek to extract cooperation with the congressional committee. We have had times where witnesses before PSI and other committees who have testified and also have faced criminal proceedings have sought to get help from a committee, a statement of their cooperation for use in sentencing, and sometimes committees have done that. Other times they haven't. There was a witness in a PSI hearing a couple of years ago who was a whistleblower on tax evasion, who won something like $100 million, I think, and all, for having blown the whistle to the government, both to PSI and to the executive branch, and also went to prison for a couple years for having engaged in the tax evasion. I think he's out of prison, I think, and still has millions of dollars.
Well, please join me for thanking these terrific panelists, sharing their expertise. And also, I was instructed to tell you guys, lunch is out there, and we do have our terrific keynote speaker speaking in here at 1:15. And so you're encouraged to get back in here pretty well before 1:15. And I'm told that you are not only allowed to, but even encouraged to bring your food in here. So feel free to, get some food, maybe mingle a bit, and then bring it back in time for the 1:15 keynote speaker.